Good afternoon, everybody, and thank you for joining us on this very hot day for our COVID-19 and employment law webinar. We're going to focus on issues related to redundancy and also cover other legal issues which are arising frequently as a concern from members in the context of the pandemic. As you can see, we have our BSL sign interpreter, Ezra Kwaziri. Just to introduce myself, I'm Julia Maguire. I am the new head of legal services at UCU, and I have been in post about 6 weeks. I've been specialised in practicing employment law in the public sector for the past 18 years. And I'm looking forward to engaging more with the issues which are important to members. So just to introduce you to our speakers, we're very lucky today to have expert help and guidance from two leading lawyers who were both eminent academics, one of whom is also a practicing barrister. That is Professor Michael Ford, QC. He is a professor of law at Bristol University and practices law from Old Chambers. He's also an employment judge and a deputy high court judge. And his cases read like a list of the most important cases which clarify and challenge the law on behalf of claimants, especially in the areas of working time, such as the right to annual leave during sick leave, and commission and overtime payments for annual leave. Michael's involved in all of that. He often acts for trade unions, and he recently acted for the Equality and Human Rights Commission in a case of public importance, which was the impact on access to justice of tribunal fees in the employment tribunal. Michael's colleague, Professor Alan Bogg, is also joining us. Alan is the Professor of Labour Law, also at Bristol University, and until 2017, he was the Professor of Labour Law at Oxford University. Alan's published prolifically in leading law publications in this area, and his particular interest in the area of freedom of association, which has obvious resonance for us, common law rights, and the importance of employment status. So just before I hand over to our speakers, just to let you know what we'll be doing about questions. Those of you who pre-registered in time have been able to submit your questions in advance, and Alan and Michael will aim to provide the answers to the issues that have been raised as they talk. But we will have plenty of time at the end to answer any outstanding questions or questions you'd like to raise in the comments or chat facility on your platform as they talk. So please do send them in. If there's questions that we don't get to, if there are any common themes or overriding issues, then we will look at dealing with those questions afterwards by member communications. And finally, hopefully you will have received, if you were pre-registered, the notes for the talk by our speakers, and you may find it helpful to follow them, but otherwise you can put them for reference afterwards. So without further ado, I'm going to hand over to Michael, who's going to start our talk. Hi, Michael.
Hello, Julia. Thank you very much for inviting us to speak on this. I'm going to talk about some of the basic things, redundancy, Section 188 consultation, and protection of fixed-term workers. And then Alan is going to deal with the more complicated stuff. For example, people not turning up to work because of health and safety risks. Needless to say, we're not going to cover everything. We've provided a detailed handout, which has been written quickly, but I hope it highlights some of the issues in this field. And really, our function today is to highlight some of the legal issues that can arise, perhaps the familiar, but also the less familiar. Now, just to really deal with some of the very basic stuff, and apologies in advance for those of you for whom this is teaching you to suck eggs. I'm looking forward to see how the interpreter deals with that one. But anyway, Employees, of course, with more than 2 years service who are dismissed by reason of redundancy are entitled to redundancy payments. Remember that non-renewal of a fixed term contract, very prevalent in the higher education sector, is a dismissal for this purpose. But I've highlighted on the handout the problem for workers on hourly paid or those on 0-hour contracts, because often the employer won't bother to take an actual decision to dismiss them, but will simply leave them in limbo, as it were. So they may have problems accessing redundancy payments. If there is an argument they were dismissed, they need 2 years continuous employment. But I've referred on the handout to some of the cases which may assist them, even if they've not been employed during university holidays, such as Cornwall and Prater, where it was held that breaks over the summer holidays where a teacher wasn't working and wasn't under a contract were nonetheless temporary cessations of work. The one thing to look out for on redundancy payments is whether there are contractual rights to redundancy payments which are higher than the statutory minimum. And this, in a sense, is a question that depends on the terms of the particular worker. So it's hard to lay down general rules on it. But insofar as you can give general guidance, the general trend of the courts nowadays is to say that individual rights to payment, that policies giving rights to redundancy payments generally are apt to create contractual rights, either by means of an express term or where the policy in the past has been to pay them by means of the implied term based on custom and practice. On the other hand, collective rights, for example, to consultation with a union or declarations that the employer will seek to avoid redundancies, are generally considered not to be apt to give rise to enforceable contractual rights. So that's the general position, but in each case, you as union representatives will want to examine the individual written terms and the practices at a particular institution to see the scope for contractual arguments. Notice pay. Remember, there are rights to statutory minimum provisions on notice pay. They won't apply where an employee has at least 1 week's more contractual entitlement than the minimum. But there is one funny little provision that you should be aware of, which isn't mentioned on the handout. That is, by virtue of section 86(4), if someone is employed on a fixed term contract for less than 1 month, but they then end up working for more than 3 months, they are treated as if they had an indefinite contract, and therefore the statutory rules will apply to them. So bear in mind that funny little exemption for any members who are employed on very short-term contracts. Now, contractual issues. It's fairly easy to state the general rules on contractual issues. I'm going to focus particularly on working hours, but let me just say something about the general contractual position. The general position is that if an employer imposes a unilateral change, that's of no effect. In the poetic language of the courts, an unaccepted variation is a thing writ in water. The general tendency of the courts nowadays as well is to say that just because individuals continue working under changed conditions doesn't mean they've accepted the change. So if wages are reduced or hours are increased in breach of contract, carrying on working generally won't be an acceptance. But the position is reinforced if 2 things happen. One is if the union objects on their behalf. So if the UCU objects on behalf of members, that will generally be sufficient to prevent the change, any argument based on implied acceptance. And even more clearly if the members themselves object. So you can adopt a double-pronged approach. One is the union objects on behalf of the members, says we don't accept this change. And the second is the members individually, if possible, object as well. The the nice thing from the union's perspective is if the union were to agree with the employer a downward change, that generally won't be effective to bind the members. So whilst the union can object on behalf of the members to detrimental changes, it generally isn't treated as their agent for the purpose of agreeing downward variations, which in any case might put the union in a delicate position. So bear in mind that that's except in the case where the union has there's an incorporated collective agreement varying the terms of individual contracts. Zero-hour contract workers again present a problem here, at least in relation to pay, because they only have a right to be paid if they actually work. And generally, under the terms of their contract, the employer will have an unrestricted discretion not to give them work. Now, there may be an argument, and we're at the outer limbs of legal territory here, for saying that if an employer capriciously or arbitrarily refused to give them work, there might be arguments based on the implied term of trust and confidence. But I wouldn't hold too much hope for those arguments, because either they may not have any contract at all on which it can bite, or the employer will say, well, we had reasonable cause for restricting your hours, namely, we're in the financial poo. I'm careful of the words I use in this context. The thing that I've seen many members raise questions about, what about increases in workloads? Well, the handout provides some detail on this, but to give you the headlines, the general law provides limited protection. There are limits in the working time regulations that the maximum weekly time is supposed to be 48 hours, which the courts have held gives rise to an implied contractual term. But firstly, members can sign individual opt-outs for it. And secondly, absent the implied contractual duty, the only enforcement is via criminal sanctions. There are other duties in tort, for example, if excessive workers cause people psychiatric injury, but once more, we're looking at extreme cases rather than everyday ones. But there are two avenues that you may wish to look at your particular institution. One is claims under the Equality Act. If increased hours of work or working at unusual hours, for instance, at Bristol, we've now been told we may have to carry on teaching till 8 p.m. Shortly, it'll be 24-hour on-call teaching. To the extent those disadvantage those with protected characteristics, there may be arguments under the Equality Act. The most obvious one is women who, as we know, the statistical evidence says usually have primary childcare responsibilities. So it may be indirectly discriminatory against women. And equally, there may be arguments under the Equality Act in relation to people who have disabilities and can't work excessive hours. There may be arguments specific into them. So that's the Equality Act challenge. The other challenge that's a possibility is under the is arguing that the increase in hours is a breach of contract. You have to be careful here. The first problem is whether or not there is a clear contractual undertaking as to how many hours you work. Quite often they're framed in vague terms, which may make them not apt to give rise to a contractual right. The second problem is the remedy, because the problem with excess hours is you don't usually suffer any loss in pay. So the employees suffer no financial loss. So the only real remedy would be to seek an injunction stopping the employer or a declaration that they were entitled to only work certain hours. Those claims are difficult, not least because in an injunction, the union supporting the case would need to give a cross undertaking and damages, which I won't go into the detail now, but makes these cases difficult. So bear in mind, you have those two issues on contractual claims. First of all, is there a contractual right at all to work certain hours? Secondly, if there is, what's the appropriate remedy?
Can I jump in there, Michael?
Of course.
Yeah, so I mean, the other issue that sometimes come up, people have been concerned about the diversion of hours from research activities from research activities to teaching preparation, and the question arises whether or not that raises any contractual issues. Now, in the end, that will be a matter of an individual employment contract and whether there's an entitlement contractually to have a portion of your time devoted to research, or indeed whether your sabbatical is a contractual entitlement. And I think very often it's the case that the employment contract will reserve the power to a head of school to direct the allocation of time in accordance with the needs of the organisation. So I've certainly found that over this last few months. I haven't opened a book in anger or thought about an employment law issue from an academic perspective, because I've been doing the transition to blended online learning. Not even sure what that means, actually. But I think there's probably not any contractual recourse for me. I mean, the other thing to note is I'm of an age now where my kids describe me as a silver surfer. So I'm not very confident with IT, and all of a sudden I'm being expected to come up to speed with things like Zoom and doing PowerPoints with fancy talkovers. And there is a duty of cooperation in employment contracts, which is an implied term that probably contractually requires me to keep up to speed with reasonable developments, and that would require me to get up to speed with these various things that I'm now asked to do. On the other side, of course, it's a reciprocal duty, and there is a duty on the employer to provide reasonable training for those purposes. So it's worth keeping that in mind when thinking about the contractual issues that are arising at the moment for academics.
Thanks, Alan. Yeah, well, that's the contractual avenue. The other thing that regrettably we have to talk about in these difficult times is unfair dismissal. Again, the handout goes you through the key outline here: need for a dismissal, need for 2 years continuous employment, and so on and so forth. There's one thing I should highlight about redundancy. In the old cases, the courts, such as Williams and Compare Maxim, the courts tended to talk about the employer having selecting a pool, adopting reasonable criteria to select who's made redundant, applying the criteria reasonably, and making reasonable efforts to seek alternative employment. Increasingly nowadays, you see employers engaging in what's called selection in. That is, they say, well, you're going to have to reapply for these new posts, and we will interview you for these new posts. And then we'll decide who gets them. If there are genuinely new posts being created, those sorts of decisions are harder to challenge, because the courts have tended to say the employer has a greater deal of subjective discretion in deciding to select people from new posts than it does if it's simply deciding who to select from a pool and who's going to be dumped in relation to existing posts. So be aware of that new management technique, which has now come to the fore, because employers realise it makes it harder for tribunals to scrutinise it. But I've given you a couple of the cases on the handout, one of which highlight that particular issue. Now, Section 188 gives rise to several questions. Obviously, I can only deal with it briefly, and the main points to note are these. First of all, the duty is restricted to employees only. It doesn't. It should extend to those who are workers under EU law, but we've still not had a case conclusively confirming that the UK law is defective in that respect, although I think Alan's involved in one that is being brought by my chamber in relation to that, supported by the IWGB.
Yeah.
So that's issue one, and that's an issue. But you may wish to think that if there's an issue as to whether or not the employer crosses the threshold, it's worth running the argument that those who are workers should be included, and that you should stretch the domestic meaning of employee to incorporate them in accordance with the very radical duty to interpret domestic law to give effect to EU law. So that's issue one. The second issue is, remember the definition of redundancy here is wider than for redundancy payments and includes reasons that aren't related to the individual. And that will include, incidentally, where fixed-term contracts aren't being renewed on their expiry. See the case of UCU and University of Stirling.
Did you do that case, Michael?
No, oddly, I've referred to a case I didn't do here for once.
That's a surprise.
The other thing, I'll come later to how the workers on fixed-term contracts may be treated for those thresholds. And the final point to note in this quick tour of the law is that the employer has to grant access to representatives, give them access to the employees and appropriate facilities. That's a particular issue at the moment where people may not be able to meet face-to-face, and there may be requirements for the union to access them via electronic means. So the duty will be on the employer to provide appropriate facilities by which the representatives can have access to the members. So that's section 188. Discrimination. Well, I've already highlighted the potential for arguments on excess hours. There may similarly be scope for discrimination arguments in relation to redundancy selection. Some of the questions I've seen from Julia highlighted those on fixed-term contracts being selected in the first instance. If those on fixed-term contracts, for example, disproportionately comprise members of a particular ethnic minority or race, or one sex or the other, or younger workers, then they may trigger the protected characteristics of race, sex, or age. And such selection criteria will therefore place those protected classes at a particular disadvantage. And the question will come in every case whether or not the employer's decision is objectively justified. Now, that's a fact-specific question, but it is rather more detailed than a higher degree of scrutiny than we're used to in unfair dismissal. So bear in mind of those particular arguments, and bear in mind of the need to have evidence that the relevant criteria does disproportionately impact those for a protected class, both at this institution, and you can also look more generally to support that by saying, well, the broader labour market supports the same. The final topic I'll quickly mention are fixed-term contract workers. Now, as you probably all know, there are specific regulations protecting such workers based on an EU directive, by which fixed-term workers have the right not to be treated less favourably than comparable full-time workers, unless the differences in treatment are objectively justified, which is a similar test to an indirect discrimination, and a relatively exacting one. The handout says, well, the failure to renew a fixed-term contract in and of itself doesn't give rise to a complaint. See the Webley case. But don't over-interpret that. The only complaint in the Webley case was that the woman there hadn't had her contract renewed. She wasn't saying, well, I was, for example, selected for redundancy in advance of others. And the Court of Appeal, not surprisingly, said, well, if non-renewal of a fixed-term contract in itself was less favourable treatment, that would mean every single fixed-term contract effectively became a contract of indefinite duration. So don't think the decision goes wider than it does. It won't prevent challenges where workers on fixed-term contracts are selected for redundancy in advance of prior to those on permanent contracts. But the treatment must be because of fixed-term status. And so if you get the application of LIFO, which has a last in first out, which has a disproportionate effect on those on fixed-term contracts, that won't be because of fixed-term contracts. status. Whereas if the employer is selecting those on fixed term contracts first, that will be because of. So bear in mind the causation problem. The real issue is if fixed term contract workers are selected first for redundancy, so that prima facie they've been treated less favourably, whether the employer could justify that. Now, in a case called Montero Mateus against Madrid in the Court of Justice, the court said you could justify higher levels of redundancy payment to permanent employees because those employees had an expectation of continued employment, whereas those on fixed term contracts didn't. And that's the sort of argument the employers will run in this context. But bear in mind the limitations of that argument, because it has less application where fixed term contracts are terminated before their term. Because if they're terminated before their term, then that's equally frustrating the expectation of those workers to have continuing employment. Perhaps more relevant to the university sector, where you've had fixed term contracts in the past persistently renewed, then you can say these workers, the fixed term contract workers, have a similar expectation as do those on permanent contracts of continuing employment. So seeking to undermine the argument on justification based on Montero Mateus. Now I'll have to finish there because Alan wants to get his oar in. There's one matter I haven't dealt with in relation to fixed term contract employees, which I know was raised in the questions, which is what about those on fixed term contracts who've been employed for more than 4 years and who have the right to be deemed permanent employees? Now, the issue is really this. Such employees are ordinarily, that is those on fixed term contracts, ordinarily ignored for the purpose of Section 188 consultation. The government took advantage of the exemption in the directive. But does the right in the fixed term regulations to be treated as a permanent employee have the effect of meaning these people are deemed permanent employees for the purpose of Section 188? I think there's a good argument they do, but it will require rather more thought and analysis than I've done for today's talk. The one pragmatic thing the UCU might think of doing here is where you have people with more than 4 years service to write to the employer under Regulation 9 and say, can I have a written statement, please, telling me whether or not I'm a permanent employee? Now, if the employer says you are a permanent employee, you know they count. If the employer challenges and says, we think it was objectively justified not to treat you as an employee, a permanent employee, you kind of know what the legal terrain you're fighting on. So bear in mind the right under Regulation 9 to require the employer to explain whether or not those who've been on fixed term contracts for more than 4 years should be treated as permanent. And we know there's lots of them. So apologies, Alan, as usual, I've gone on a bit long, but over to you.
Right, so Michael's very helpfully left me with about 1 minute and 30 seconds to get through my material.
No, we've got to 40 minutes, Alan.
Oh, right, I thought we were 30 minutes.
No.
Right, so I've got 10 minutes then. So thank you very much for going through that material, Michael, so carefully. And what I want to sort of finish up on is the kind of really interesting question of whether there is a right to refuse unsafe work. So I've been on Twitter now for about 18 months. I'm delighted to tell people that I got to 3,000 followers yesterday. So I'm very excited about that. I got more followers than Michael. I might not be a QC, but I think I'm more of a social media star. But one thing I would say about Twitter is that it is prone sometimes to rather extravagant claims about what legal entitlements there are. And sometimes I think that's a product of wishful thinking. and maybe a product of very bold interpretations of the current law. I've seen it said that there's a basic right to refuse unsafe work if you believe that your workplace is unsafe. And I think we need to be very cautious about that, because I don't think that's a fair reflection of the current law. So there is a limited right to refuse unsafe work in exceptional circumstances, but I think it's important for us to just go through what that right encompasses, because it's better, I think, to be informed with a proper understanding of what your entitlements are, and to be forewarned is to be forearmed. And this is obviously very important. People are anxious. Many institutions, academics don't know whether they are coming or going. The advice changes from week to week. I basically teach in a very small office in the basement, and the idea of squeezing 10 students in there isn't filling me with particular excitement when I think about them coughing and sneezing on me, which is what they do every October. So the key provisions I think people have in mind when they are thinking about this right to refuse unsafe work are sections 44 and 100 of the Employment Rights Act 1996. And these are provisions based upon European law and the Framework Directive on Health and Safety 1989. Actually, one could go further back than that. You see similar provisions in the 1981 ILO Convention on Health and Safety. And it's obviously critical in a situation of emergency that employees have the right not to work where there is an imminent risk of danger to themselves or others. So Section 44 of the Employment Rights Act 1996 covers detriment. So that's where you're subjected to a disadvantage in certain circumstances. And Section 100 covers situations of dismissal. But in relation to 44 and 100, the substantive scope of protection is common to each of these provisions. So the difference is one of them applies where it's a disadvantage that falls short of dismissal, and Section 100 covers a dismissal situation. So the first point to note, if we look at the kind of detail of those provisions, is that they only apply where there are circumstances of danger. So that's that's not simply a situation where the work is regarded by the employee as unsafe. It has to be circumstances of danger, and that may or may not be applicable in a given situation. Now, the second requirement is that the employee has to reasonably believe that the circumstance of danger is serious and imminent. So there are three features there that we need to kind of just pay attention to. The first is that it's a right for employees. It's not a right for workers. So that means in situations where you have casuals, they may be people who work on a casual intermittent basis. They may not, in UK employment law terms, count as an employee. They may be a LIMBY worker. The second requirement is that there has to be a reasonable belief. So it's not simply enough that the employee believes that there's a danger, which would be a purely subjective test. There is also an objective dimension, which is that the belief has to be reasonably grounded. Now, the third requirement is that the risk needs to be both serious and imminent. Now, in terms of seriousness, Obviously, the implications of infection for not just people in vulnerable groups, but any individual would probably count as serious. The question that might be trickier is whether the circumstances of danger present a risk that is imminent. And I think the imminence requirement is really just trying to underscore the fact that this provision is envisaged as a last resort rather than a first resort. And if those requirements are satisfied, then the employee has a right to take appropriate steps to protect himself or other persons from the danger, or to withdraw from the dangerous situation, or to refuse to attend work. So those are the two rights that one has, and one is protected then from detriment or dismissal. So I've already said that the provision is restricted to employees. Now, there's currently a case ongoing, a judicial review, where the IWGB is challenging the restriction of the domestic provisions to employees, but that for now is what the law is. I think in many cases that will be okay for many people who work in higher education. The only particular difficulty might be where you are a casual engaged in work on an as required basis. It may be in that situation the hurdle for demonstrating employee status is elevated. The second point is this is day one protection, so you don't have to worry about continuous employment. It's a day one right, so you're protected from day one, which is important. Subparagraph E extends to other persons, so it's not just a danger to the employee herself, it's to protect herself or other persons from the danger. Now, in Maziak, this was a case involving a chef who rather valiantly decided not to subject customers to dodgy chicken. And the EAT took the view that customers would fall within the scope of other persons under this provision. And my view would be that this could well extend to students. So you might take the view that students are other persons, or shielding members of one's family potentially could be included within the scope of other persons. The other issue that I think has attracted quite a bit of attention is whether sections 44 and 100 extend to travel to work. Now, this is obviously an important question, and particularly when universities are extending teaching hours so that we're all expected to be available 24/7. How far does this provision extend to travel to work? Now, there is a case, Edwards, where the court took the view that travel to work was included within the protective scope of these statutory provisions. Now, as Michael will point out and has pointed out to me, we need to be cautious about Edwards. That involved a situation where the employer itself was providing the transport to and from work. So the question arose whether prison officers could refuse to undertake the journey when there had been extensive snow. And I think it was a rather precarious drive out to Dartmoor. And the tribunal took the view that that was encompassed within the provisions. Now, whether that now extends to using public transport in an ordinary situation, particularly given the fact that now there are extensive public health measures in place on public transport, remains something of an open question. circumstances of danger must arise from work-related risks. And there is an argument, I suppose, that travelling to work, if the risk arises from the travel, it's not a risk that's arising out of the work situation. Against that view, I think I would make the point that the European Court of Justice has taken a very wide interpretation of health and safety and has adopted a broad, purposive and ergonomic interpretation of that concept. And that might well embolden a court to do likewise in interpreting these provisions under section 44 and 100. But I suppose my kind of overriding view of these provisions is that one just needs to be cautious about their use. They are regarded, I think, as an exceptional measure where there isn't a realistic opportunity to avoid an imminent risk. And I think there are three other responses that are probably likely to be more valuable as practical tools for union members and union organisers. So the first is to make full use of general health and safety law and measures through health and safety representatives. Actually, what we want to avoid as a union is situations where employees are exposed to dangers. And the virtue of the general health and safety framework is that it's proactive and preemptive. And it's far better for us not to be exposed to unreasonable risks, rather than as individuals for us to exercise effectively a right to self-defense. That shouldn't be regarded as a kind of an attractive strategy. That's a fallback. The second alternative is whistleblowing protection. So if as a whistleblower you raise concerns about health and safety, that counts as a protected disclosure under the relevant legislation, and you have the availability of interim relief. Now, with whistleblowing protection, there's always the difficulty that the employer will argue that the reason for detriment or dismissal is not the fact of the protected disclosure. But whistleblowing protection is a powerful measure and may be actually broader in effect than section 44 and 100. And finally, disability discrimination. So if you have a vulnerability, it may well count as a disability under the legislation. If it does count as a disability, then your employer is under a duty to make reasonable accommodations for your disability, which may involve agreeing arrangements to work from home rather than being required to do face-to-face teaching in the workplace. And the advantage of that is that it's individualized and it's tailored to the particular risks and situation of the individual with the disability. And I think that actually, for many cases, may be much more attractive than relying on section 44 and 100. If it's possible to bring yourself within the scope of disability. But that's me done. Thank you very much for the opportunity to come and speak to the UCU. It's my union, it's our union, and it's been a great pleasure to share the last 15 minutes with you.
Thank you, Alan and Michael, for your very detailed contributions. We do have some questions. The first one, I think, draws on what Alan was just discussing. Doesn't a pandemic, by definition, mean an imminent danger? Would you like to deal with that one, Alan, in the context of section 44 and section 100?
Sorry, I unmute myself. So my view of that would be, I think the question would be whether the circumstances of danger in the workplace as they relate to that particular employee count as a kind of imminent danger. So I'm not sure one could invoke the generalized situation of a pandemic. I think the question would be probably much more particularized than that and focused on the individual employee in her working environment, because obviously, the risk factor will vary very widely across different sectors and different workplaces, even in a situation where we're all faced with the same pandemic threat. So that would be my view. What do you think, Michael?
Well, the old coronavirus health protection regulations used to refer in the preamble to the serious and imminent danger arising from coronavirus, which some people, including me, picked up on and said, well, this is clearly an acknowledgement the risk is serious and imminent. But along with Alan, I think it's a rather more nuanced question when you're focusing on the scope of the section 44 at 100, where I don't think simply declaring, well, this is imminent, this is an imminent risk, or this is an existing risk, helps really answer that more difficult statutory question.
Just a question following on from that, really. I noticed, Alan, you were careful to not raise expectations too much about the utility of section 44 and section 100. And I just wondered, as a context for how we would define imminent danger, are we talking about a similar test to the one the court uses when it just considers whether prison officers in prisons where there's a situation of potential breakdown of order, and prison officers, if they're in imminent danger, they can lock themselves out as a means of protection? Are we talking about that kind of imminent danger on that scale?
So that's a great question. In my kind of second job, I'm a criminal lawyer, as well as an employment lawyer. So the context where I encounter imminence is within the context of technical assault, and the question whether a threat of bodily injury is an imminent threat. That's part of the definition of the offence. And one thing that's interesting is that the concept of imminence is rather like an accordion. So in different cases, imminence is stretched out, for example, to encompass telephone assault. Now, if you're being threatened down the telephone, it's unlikely that you're of the view that you're going to be attacked there and then, unless the person stood outside your door. But the courts have interpreted imminence quite widely in that kind of situation. And I think there's a good argument here to say that in the current situation, given the existence of very serious and publicly acknowledged risks involved in many forms of work, I would take the view that the imminence requirement would not be interpreted as stringently as your prison officer example. But I think the difficulty with it is you won't know until you end up in the tribunal, potentially. And there are extensive delays now. There already were extensive delays in the tribunal system. And I think my view is, don't be afraid to use this provision if you really do feel that you're being exposed to a danger that falls within the scope of the section. But what I would hope is that union organisers at branch level would actually be working proactively on this, using disability discrimination, using general health and safety legislation, in order to avoid the need for this provision.
Yeah, I think I'd be quite cautious on this. I mean, if you look at the case of Edwards and Secretary of State for Justice, they said, of course, it's a fact-specific question based on the individual's subjective position, but also applying an objective test. But they looked at three things in particular, the employee's individual vulnerability. Of course, if you're someone who's vulnerable and should be in accordance with the relevant guidance from Public Health England, then I think your arguments are much strengthened, because you can say, look, the public health bodies recognise there's a particular risk to me. So that's in your favour. If you're not vulnerable, then there's not much weight to that factor. The second factor they looked at were the precautions taken by the employer. So, of course, if your employer is doing nothing, then you can say, yeah, I can stay away. But if they are taking measures to ensure PPE is used, to ensure there's aspects of distancing, that becomes weaker. And the third factor is what other employees did. So if you're one going out on your own, it's less likely that the section's going to protect you. But I think as well, you've got to bear in mind the background factor here, because an employment judge is going to be critically aware that if they were to decide that simply attending an ordinary workforce for a non-vulnerable employee is a serious and imminent danger, that, you know, they potentially made a decision here which would echo across the whole of the UK workforce. And, you know, they're not necessarily conservative people, but on the whole, I think judges are going to be very, very conscious of not making a decision where they are implicitly recognising that a normal workplace with social distancing measures is effectively a serious and imminent danger, meaning that anyone can turn up to not to work.
Thanks both for those answers. The next question that's come in is kind of on a similar theme, but more of a practical question. How much notice does an employer need to give to require a return to face-to-face teaching? And I would also add to that a question which has been arising is any form of detailed risk assessment needed, or would that only be for employees who are potentially more at risk or have been shielding?
Well, the duty to make risk, if I can go in on this one, Alan, first, the duty to make risk assessment under the Management and Health and Safety at Work regulations extends to all risks arising from work. So I don't think it's just shielding. I think it applies to everyone. There's the duties to provide suitable PPE under the PPE regs. There's the duties to provide, ensure workplaces are properly ventilated and the like under the workplace regs. So I don't think that it's just for shielding employees. No, I think the risk assessment duty extends to everyone. So that's route one. And as Alan mentioned, you've got the duty to consult with recognised, or even if there's no recognised, representatives under the relevant regulations. In relation to the specific question of how much notice they need to give, well, arguably, you need to look at the individual contractual terms, but I imagine most contracts won't deal with this because there'll be nothing said about it. You know, it's an exceptional circumstance. So in the absence of an express term, the answer is, well, it's just got to be consistent with the overarching duty of trust and confidence. So I think provided they give you a reasonable indication and have a chat with you that you've got to go back and do that, that's probably sufficient, provided always that they're meeting their duties under health and safety law first and foremost.
Yeah, I mean, on the question of notice, I think the relevant case law that comes to mind are issues around contractual mobility clauses. So there's a case, United Bank and Actar, and the question arose in that case, what did the employer need to do by way of notice under the mobility clause in order for the instruction to be contractually compliant? And of course, the question the court gave was that the notice had to be reasonable within the context of that particular power. And I suspect that's the answer that you would get from a court, that the notice needs to be reasonable notice. That will be sensitive to the individual's particular contractual situation. I suspect that reasonable notice might be different for somebody with underlying vulnerabilities as compared with an employee who does not have underlying vulnerabilities, but it would be a question, and it would be a question of reasonableness, and the notice would need to be reasonable. I think for somebody in my situation with no underlying health condition, I imagine that what counts as reasonable notice would be relatively short in order for it to be contractually compliant, my view.
Thank you both. We've got a few minutes left. I just want to deal with a question on the theme of redundancy. You mentioned I've noted in the handout a mention of the case law on the definition of establishment for the purposes of collective consultation, and we have started to notice a sort of a trend for large universities to name the individual department as the establishment for the redundancies, so as to presumably avoid having to aggregate the numbers across the university. So could I have your views on that practice?
Well, you're talking of the Woolworths case, where Woolworths was able to say that each of its individual stores was a separate establishment, and so you didn't get aggregation across each of the stores. To be perfectly frank with you, I can't remember the precise factors the Court of Justice took into account in deciding when establishments are separate. But if you give me a second, I'll just find the relevant provision in the directive. I don't know if Alan wants to add something in the meantime.
Right, well, yeah, I pay particular attention to that case because I used to love pick and mix from Woolworths. So I tuned in with great interest because I was devastated when Woolworths disappeared. So what I'll do while Michael looks for the correct answer is do what I did for 15 years doing tutorials, which is make it up off the top of my head and sound confident. What I actually do think is that it's very difficult to say, I think, that a department in a university is analogous to an individual Woolworths shop that has its own autonomous management structure within a wider organisation. So Michael will be able to give us chapter and verse on the Woolworths decision, but it seems to me to be spurious to say that a department within a university is analogous to a distinct establishment for the purposes of aggregation. I'd be very surprised if the Court of Justice were to take that view. Has that bought you enough time, Michael?
Not quite, Alan. I looked at the directive and it just says establishments and it doesn't define it. So we need to go back and look at the Ethel case. But like Alan, I would be very sceptical indeed of a court saying that university departments are separate, because you tend to have a single HR management sitting above them. The degree of intertwining of one department with other departments is usually intense and detailed. So I think it would look extraordinarily that artificial to me to start saying, well, you divide universities up into faculties, schools, departments. It looks like a device to try and get round the directive. So I wouldn't have thought a court was sympathetic. Having said that, I always thought Woolworths was a slam dunker for the union in that case, as I think the unions did. So I was pretty surprised when the court came to its decision.
Yeah, and if I could say, I mean, a key issue I think in Usdahl, having just done a quick Google search, was the geographical dispersal.
Yes.
Of stores. Now you're very unlikely to have geographical dispersal on a university campus. So yeah, my lawyer's gut is telling me that if that kind of activity is being undertaken, it's definitely worth a pushback.
Yeah, and you've got to think of the implications, because effectively it opens up to every employer again to say we've got separate departments. It's a very, very unattractive argument.
Yeah.
That's great. Thank you both. I'm just mindful of the time, so we need to wrap up now, really. So one thing that has come out of the talks quite clearly is, I think, the limitations of legal remedies, particularly at the moment, at a time when I read today that the backlog in employment tribunals is increasing by 1% per week. And there are currently a backlog of 36,000 cases. So any cases that do get to the tribunal are not likely to be heard quickly. So on the back of that, I just want to stress the importance of campaigning and organising. So if you are encountering these issues, get in touch with your regional office or get in touch with bargaining and negotiations so that we can build some momentum on these issues. I'd also just like to thank Alan and Michael for their very comprehensive and interesting talks and answers. We're even more lucky than I realised at the beginning. Not only do we have a QC, we also have a social media influencer and a criminal lawyer to speak to us. So we appreciate your sharing of your expertise, both of you, with us. We hope this webinar has been useful for you. Very grateful to receive any feedback from Communications. And thank you for attending. Goodbye, everyone.